Well, good afternoon. We welcome you to the question and answer session related to the Professor Frost lecture, Lex Est Rex. And thank you, Professor Frost, for your very enlightening and informative and thought-provoking lecture. And may I start with a very basic question? We had lots of people who called from all over the world. Some of them were professors of history or of law, some were students, some were, so to speak, civilians interested in Polish history. And may I ask you the very basic question to kind of frame your talk? Can you tell us a little bit about Polish-Lithuanian Union? You know, how did it come about? What its origin? How it evolved? Some kind of basic brief history that would help people understand your talk better.
Sure. The Polish-Lithuanian Union was a remarkable construction. Much of the political history of Europe is written around the concept of the rise of the modern state. And this has handicapped understanding, I believe, of many of the late medieval and early modern political constructions in Europe, which were composite systems of various kinds. Monarchs inherited different territories, different states. And there's a literature on that about composite monarchy and composite states. And the idea is that this was a sort of medieval thing that was old-fashioned, and that the rise of the modern state eclipsed that with Max Weber's idea of the modern bureaucratic state that we now all live under. But the Polish-Lithuanian Union was, to my mind, a remarkable union, and in many respects I compare it to the British Union, because they're often seen as being similar. They are often seen as being personal unions, unions only of the crowns, to put it in British terms, that began between Poland and Lithuania in 1396 and in Britain in 1603. But I think they're fundamentally different, because I think the Poles and the Lithuanians were doing something rather interesting. The union came about really by accident. The Lithuanians were a pagan tribe who ruled this enormous composite system, I would call it. The rulers of Lithuania, who were pagans, they spoke Lithuanian, a Baltic language, had extended their rule and received homage from a large population of Orthodox Eastern Slavs, the ancestors of today's Belarusians and Ukrainians. And they had, because Kievan Rus, which had been a similarly composite system in the medieval period, had been overthrown by the Mongol invasions of the 13th century. And the Lithuanian princes picked up the wreckage and ruled it very effectively for some time, down till the 14th century. But in the 14th century, they came under pressure from the Teutonic Knights, who wished to Christianize this last pagan state in Europe, if you like, or this last pagan people in Europe, because this, as I say, the majority of the inhabitants of the Grand Duchy of Lithuania in the 14th century were Orthodox Christians. And by the 1380s, there were problems. There were dynastic problems within the Gedyminid dynasty, the ruling dynasty of Lithuania. But there were also dynastic problems in Poland, where Casimir III had died in 1370 and had left his throne by agreement to Louis of Anjou, the King of Hungary. But Louis had no sons. He only had two daughters, and he set up an agreement with the Poles that the Kingdom of Poland would be inherited by one daughter, and he set up an agreement with the Hungarians that the Kingdom of Hungary would be inherited by the other. Well, to cut a long story short, the Poles decided that yes, they would accept one daughter, but not the one that Louis had intended. He wanted Mary to be Queen of Poland and Jadwiga, Hedwig, to be Queen of Hungary. But the Poles said, no, we want Jadwiga, who was 12. And they decided that to extend their interest to the east, it would be a good idea to marry her off to the Grand Duke of Lithuania, Jogaila, who was a pagan. And the agreement was that Jogaila would turn Christian, would turn Roman Catholic, would persuade his cousins and brothers to turn Catholic too, at least the brothers who weren't already Orthodox, and would make his people, the Lithuanians, the Baltic-speaking pagan Lithuanians, he would make them into Roman Catholic Christians. And that's what happened. You then had a century and a half in which the Poles and the Lithuanians argued about what the nature of the union was. The Poles, who felt very superior to the Grand Duchy of Lithuania, said, oh, well, what Jagiellon did, he became Władysław II Jagiełło in Polish, what Jagiełło did was incorporate the Grand Duchy of Lithuania into the Kingdom of Poland. And the Lithuanians said, no, 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 no. This was a union of equals. We had equal status. And this was a well-known concept in late medieval and early modern Europe. The idea of a union equiprincipaliter was called in Latin, which was each side had the same status, they got to keep their same laws, their same customs, they shared a ruler. Now, this was very different from Britain, which was essentially a personal union, but the Poles maintained that this was a real union, and they backed it up with treaties. The Treaty of Horodło in 1413. And I won't go into the details of that, but over time, it became clear that the Lithuanians would not accept the Polish vision of incorporation, and they stood out for a union of equals. And when the Jagiellonian dynasty began to die out in the mid-16th century, they had a crisis. Muscovy had revived and was claiming all the Orthodox lands that Lithuania ruled over, and the Lithuanians were incapable of defending those lands and needed Polish backing. So the union needed to continue. But the Poles said, we want a closer union. We want to execute the union of incorporation that we agreed with you all the way back in 1386. And finally, the two sides reached agreement at Lublin in 1569. And this is what I argue, and which is sort of the background to the talk I gave, was that the Lithuanians effectively won. There was serious pressure from the lesser Lithuanian nobles who were tired of being dominated by a handful of great families, of which by the mid-16th century, the Radziwiłł, the Radvila, were the greatest. And a small handful of Catholic families dominated politics. This did not please the great Orthodox princes of particularly the Ukrainian lands, Volhynia, like the Ostrogski, because they were excluded under the terms of the Union of Horodło from central office, although they were very powerful. Ostrogski was the man who won the Battle of Orsha against the Muscovites. And in 1569, there came a crisis and negotiations at the Lublin Sejm. The Lithuanians, led by Radziwiłł the Red, stormed out of the Sejm, at which point Sigismund August, the King of Poland, turned to the Ruthenians, the Ukrainians effectively, and said, would you like your own unions with the Kingdom of Poland? Now, it's often presented as an annexation, but this was not the case. After much humming and hawing, the three palatinates of what is now Ukraine, of Kiev, of Bratslav, and of Volhynia, agreed their separate treaties of union with Poland, were incorporated into the Kingdom of Poland, and kept their own law and their own language and all sorts of guarantees about keeping their self-government and local customs. But they also had, from 1566, the extension of this Polish system of local land courts elected by the local nobility and local sejmiks, which elected members to the central Sejm. Now, this was something that the Lithuanian nobility, the Roman Catholic Lithuanian nobility, wanted as well, because they wanted to break the domination of the great lords. And in the end, what was agreed was a union of two states, the Kingdom of Poland, which now contained these Ruthenian palatinates, these Ukrainian palatinates, and the Grand Duchy of Lithuania. And the formula that solved the problem of equal status was the idea of a republic, a common republic of noble citizens, united, which united two states and two nations, and it says so quite clearly in the Union of Lublin. Now, this was a remarkable political construct, unique in early modern Europe, and it explains a lot of the separate path of development that the Polish-Lithuanian Union undertook, and it underpins that different concept of the law that I was trying to outline in the lecture, that this was a system of republican law that drew on the heritage of the Roman Republic as it was understood in the Renaissance, and which did not talk about state sovereignty and the sovereign. It talked about the mixed system of government, of which the king was a vital part. The king was necessary for the functioning of that system. But the two other elements of that mixed form of government, the aristocracy or the rule of the best, i.e., the senators in effect, those major office holders, the palatines, the voivodas, the castellans, and the government ministers, and the Roman Catholic bishops sat in the Senate, and that was the aristocratic part of the constitution. And the ordinary nobles in their semics who elected envoys to the central Sejm, the common Sejm after 1569 for all parts of the Commonwealth, that was the basis of that republican system, of that union. And the union would not have survived without it, because it was built from the bottom up. Historians often say it was that the problem was decentralization, because they have this concept of state building in their minds. But it was an uncentralized system, and it had to be uncentralized. Power had to lie, or some control had to lie, with the local semics. Otherwise, as one Lithuanian said when they talked about abolishing the so-called liberum veto in the 1650s, the idea that one member of the Sejm could block legislation and block the proceedings of the Sejm, Lithuanians said, look, if you abolish the liberum veto, we will be dominated by the majority polls, and the union will be no more, because we have to have the ability to reach consensus through objecting to things that the polls just want to carry by majority vote. And the defense of minority rights within a majoritarian system is a big problem for modern democracies to this day.
Yeah. Yeah.
I hope that's not too long, but I hope it sets what I said in context.
This is fantastic. This is really very helpful. So yes, so I was just wondering, because it was my next question. You mentioned this idea of republic, and the idea of republic was changing from Roman times to, let's say, Enlightenment period. You know, American Revolution, Polish 1791 Constitution, that kind of thing. And it seems to be, though, that you are saying, or maybe maybe you're implying that actually one of the dominant kind of threats of those three conceptions, the Roman, the Polish, Lithuanian, and the later Enlightenment period, was actually the separation of power principle.
Yes, the whole idea of the mixed form of government, which goes back, of course, to Aristotle and Polybius, is that power needs to be checked. You know, they don't have a concept of the separation of powers in the way that the 18th century developed it, and of course was embodied in the American Constitution. They didn't think of it in those terms. They didn't think of the executive and the legislature and the judicial branch of government. But they did think of checking power to ensure a balance. And in the 18th century, which is an entirely different matter, the ideas of Montesquieu and others did start changing Polish republican thought. And, of course, in the Constitution of the 3rd of May, they reformed their republic, informed by what had been going on in America and France. They took a great interest in the debates on the American Constitution. And that enabled them to break out of, in a way, the Aristotelian prison of the mixed form of government. But nevertheless, they did have their whole system was based on the idea that power had to be checked, that unchecked, the power of the monarchy degenerated into tyranny. But they were out of step with the rest of Europe, who adopted this idea of Jean Baudin, who hated the mixed form of government, partly because he knew about Poland because of the election of Henry of Valois, and he met the Polish ambassadors when they were in France to come and impose their terms on Henry. Baudin hated the mixed form of government, and so produced this modern idea of sovereignty, of indivisible sovereignty, that he thought should lie with the king to restore order in France. And that idea of sovereignty took off across Europe. It was very convenient for kings, for monarchs, because they could then adopt this idea that they were the personification, the legal personification of sovereignty within this abstract state. Well, that debate doesn't really have purchase in the Polish-Lithuanian Union, according to me. That's my idea, and I'm not sure that everybody agrees with me, but there you are.
Yeah, no, that's fascinating. So from the legal perspective, like even in the United States, even in a constitution, American constitution, there is a separation of power, but actually the idea, the judicial power would be the one who checks whether, all the laws are in agreement with the constitution. That's a law developed by the courts, the Marbury versus Madison and so
Yeah,
on. So
sure.
it's actually judicial construction that gives the power to the judiciary. And we still have a problem in many countries with this counter-majoritarian kind of idea, like in the populism, that idea that the
Yeah.
majority, 51%, is good enough to rule, and we're not going to worry about the minorities. And,
Yeah, which is causing great division in Britain at the moment with Brexit. But
or in
there we
Poland,
go.
right now at the moment.
Yeah, I mean, there are some who insist on calling the Polish-Lithuanian Union after 1569 a federal union, but I don't think it is, precisely because the modern idea of federalism depends on that argument about sovereignty. The whole argument in the American constitutional debates, as you know well, was about where sovereignty lay. Did it lie with the federal union or did it lie with the individual states? And that's because sovereignty is conceived as being indivisible. And it was a huge problem for the American states in the 1780s before they finally reached their agreement. But because the arguments in Poland-Lithuania in the 16th century were not about sovereignty, I don't think you can call this a federal system. It makes it appear more modern than it actually was.
Right. No, that's very helpful. And one more comment, on the liberum veto, I would like to mention that I do think that even liberum veto is kind of very maligned in Polish history. We Poles tend to see it as the reason for our downfall. I mean, we all see the history of Polish-Lithuanian Union. That I say we see through this lens. Why did Poland fall? It fell apart because of the imperfections of the union. So that's our kind of peculiar Polish insecurity. And liberum veto is very much maligned. You just explained the logic for it, but actually I am seeing it even in European Union right now. It's existing in certain forms, and they're also struggling with the idea there is no perfect balancing of those rights.
No, I mean, part of Britain's problem with the European Union was the idea that it wanted to create a super state in which sovereignty would lie in Brussels, and that's why the Brexiteers objected to it. And the Liberum veto, lots of the Remainers said, well, look, we have a veto because we are a sovereign power within the European Union. That's the way the European Union is constructed. But yeah, the Liberum veto, of course, in the 18th century, from really the 1670s, 80s, it became corrupted, and foreign ambassadors, especially the Russians, could use it. The Russians have been manipulating other people's consensual systems for centuries. They know well how to do it. And the Liberum veto was abused in the 18th century, although the system was robust enough in the end to get round the problem. And in the end, of course, in the Constitution of 3rd of May, it was formally abolished. But really, the nature of the system was consensual. The Sejm was not a representative parliament. It was a body of envoys from the Sejmiks, and they had to take the decisions of the Sejm back to the Sejmiks, because that's where power, where really ultimate authority lay. The Sejmiks had to agree to what the Sejm decided, because they were responsible for collecting taxes and for implementing the statutes that the Sejm passed. So it was more akin to, say, the States General of the United Provinces of the Netherlands in the 16th and 17th century, rather than the English Parliament or the British Parliament. So.
Right, thanks. So that's super helpful. Now, can I ask you the second introductory question that I have? Because you mentioned Szlachta, and to many people that's an unknown word, unknown concept, and there is lots of actually debate, because I even seen like scholarly articles that Polish Szlachta was akin to the caste system in India. And I know. So would you describe it in your words? How do you feel about it, and how do you see this breakdown of the society, both in Poland, Lithuania, and Rus?
It was the idea of the noble citizen that was key. Poland-Lithuania was what the Germans would call a Ständestaat. It was a system of estates. There were separate estates. There was the urban estate, there was the noble estate, and there were various other corporate bodies within society. This is a very pre-French Revolution idea. that were in different ways privileged. And yes, Polish-Lithuanian nobles had a great problem in Europe because other European political commentators looked at them and said, well, you talk about your form of government, the mixed form of government, but all the citizens are noble, i.e., the Sejm is an entirely noble body that's elected by the ordinary nobility. Now, this reflected the remarkably different nature of nobility in Poland, because Poland and Lithuania, but more in Poland and Lithuania, and certainly more in Poland and Lithuania together than in the lands of what is now Ukraine. There were a very large number of nobles, probably about 6 to 8% of the population. You'll see figures for about 10%. But a very, nobility was transmitted to all the children of nobles, and therefore there were perhaps 1 million nobles in Poland, Lithuania on the eve of the partitions, compared with, about 1% in France. And you can fit the entire peerage of England into one room.
Right.
Tiny little room, the House of Lords. So this is a very different, they often translate Szlachta into English as gentry, but that's not right, because the Szlachta is a legally privileged estate, whereas the gentry in England are commoners. The second son of the Duke of Bedford is a commoner at law. He has none of the privileges of a peer, unless his older brother dies and he becomes a peer. And that's a fundamental difference.
Yes.
So, and other commentators in Europe look at Poland, Lithuania and say, well, look, you say you're a mixed form of government, but the people is only the nobles. Where are the others? Where are the commoners in this system? And it was something that the Poles and Lithuanians found hard to answer up to a point. But this was their republic, their community of noble citizens. And in fact, it wasn't entirely noble in that in Royal Prussia, there were the great cities that's Gdańsk, Torun, and Elbląg, sat in the Senate. There was the Sejmik in Royal Prussia, the Landtag, was bicameral. There was a Senate in which the representatives of the three major cities of Prussia, Royal Prussia, sat. And until the early 1660s, representatives of the small towns sat in the lower chamber of the Prussian Sejmik, and they sent, all the representatives, all the envoys they sent to Warsaw to the Sejm were noble, but at least there was an urban voice. But the cities themselves took on this republican idea. They were self-governing communities under German law, Magdeburg law or Kulm law in Royal Prussia, Chełmno law. And they fully bought into this idea of republican government. Even private cities, which used to be dismissed by historians of the urban class in Poland, Lithuania, but private cities were very important. Most private owners wanted their cities to flourish and gave them considerable rights of self-government. Okay, they had to agree major questions with their noble owner, but they were effectively self-governing urban republics. And the cities didn't really want to send representatives to a Sejm that was dominated by nobles. They sent observers who could lobby for the city's interests. The best sources, some of the best records of any parliamentary body in early modern Europe are the massive volumes of material in Gdańsk in the archive, because Danzig sent its representatives to sit and observe the debates of the Sejm, and they wrote everything down. They wrote everything down in German, which has caused quite a few problems. They're the best source on the Polish Sejm, the most copious source on the Polish Sejm, but they're in German. They put the jokes in Polish because they're not funny in German.
So that's great. So you actually addressed one of the questions that came through. So we described the judicial system or representative system of the Szlachta, and you actually answered the question as to cities. So that brings me to another estate, which is the Polish peasantry, because originally under Piast system and the statute of Wiślica, they have their, the justice in a village was administered by the sołtys, the peasant, risen ruler, not ruler, but the authority figure in the village, etc. And with the rise of privileges, we are seeing the steady diminishment of that role of sołtys and bringing it under the power of the landowner, the Szlachta member, right? So can you address this whole issue of justice among the peasantry and what kind of cases we have, what records we have, what happened there?
Yes, it is one of the most interesting questions in modern historiography regarding Poland-Lithuania. I would say that there is no area of the history of Poland-Lithuania that has been transformed more radically since the fall of communism in 1989 and between 1989 and 1991, depending which part of the Commonwealth you live, former Commonwealth you live in, than the history of the rural population. And I rather follow Bill Hagen and his excellent work on the system in Prussia, the agricultural economy of Prussia in the early modern period, intending to try and avoid terms like peasant and serf. Bill Hagen talks of villagers. Mm-hmm. And it's very interesting because, of course, under communism, you had this picture of an oppressed class that was constantly rebelling, that their legal rights were taken away, up to a point. And yet we are now rethinking the nature of that system and understanding it on its own terms. The villagers that were ruled by the nobility were called, as they were in Brandenburg, Prussia, they were called subjects, poddani. They were the subjects of their lords. Now, a lot of attention is given to the supposed stripping of peasant rights and the imposition of, labor service. They had to robot, as it was called, or pańszczyzna, that which was owed to the lord, the pan. That was labor rent. They worked for a set number of days per week on the estates of their owner. And this is regarded as the second serfdom. And this is a reason for Poland being backwards, because in England and in Western Europe, serfdom was abolished and we had free peasantry and we had free ownership of property and all the rest of it. Well, that comparison has come under serious question in the last 20 or 30 years. Yes, we are told that the peasants were stripped of their rights of free movement in the 1490s. Well, actually, the statute said to leave the village, peasants had to have the permission of their lord, which is rather different. You will find in popular books, oh, well, the peasants were chattels of their lord. They weren't. They weren't serfs. There was 90%, between 80 and 90%, depending on where you were, of the population lived in the countryside. It was a highly hierarchical system. The wealthy peasants who owned reasonably large holdings were the key to the system, the kmieci, the kmetones, as they were called in Latin. And they were like gold dust. In Eastern Europe, in Poland, Lithuania, the problem was not land. There's plenty of land, but land is worthless without labor. Now, in the 14th and early 15th century, the system had been based on cash rents, but the Black Death had destroyed that system. The market for agricultural products collapsed. And I shall call them peasants, so I don't like using the term because it is a little bit pejorative. Let's call them villagers. The villagers took rational economic decisions. if there was no point in of producing for an agricultural economy in Europe that was collapsing, then you just took land out of production. And you didn't have money to pay cash rent. So the imposition of labor rent was not something that nasty, cruel lords imposed on their peasants. It suited both sides. Lords needed labor, but they needed labor who could actually produce for them something that mattered. And labor rent suited the peasants. There wasn't any market to sell their produce on. And the wealthy peasants, the kmieci, they didn't perform labor service. They had to supply labor to the lord for the stipulated number of days in the week. But it was the poor landless villagers who supplied it. Sometimes they sent their children, or they would hire the komornicy, the ogrodnicy, the zagrodnicy, depended, they were called different things in different parts of the Commonwealth, they would be given, sometimes popular histories write as if medieval Europe was a wage-earning economy. Outside the towns, it wasn't. You got supplied with a little garden, perhaps, a little bit of land to work. You got supplied with a place to live. And in return for that, you performed the labor service on the manor of the noble. Now, that was the system. And in 1518, so it is said, they were stripped of their rights of appeal to the king. Well, all that happened in 1518 was the then king, Sigismund I, said, I will no longer hear appeals from village courts and baronial courts, let's call them, of the Schlachter, to my royal court. Well, the idea that peasants were queuing up and being able to appeal to the king in large numbers before 1518 is fantasy. The king couldn't even resolve the myriad of cases that were appearing from the nobility. He didn't have the time. And actually, what the courts that were run by the local Schlachter did within the village, and by the Soltis, who was by the 16th century usually a noble appointment, if not, the owner himself performing that judicial function. Most of the cases were between peasants. The noble owner had to regulate disputes between individual peasants. Yes, of course, an individual peasant wouldn't take the noble to his own court because he'd lose. But labor was like gold dust and you had to watch it. Now, yes, there were laws passed against peasants absconding, running away. But many of the laws were passed to protect the smaller nobility. As I said, labor was valuable. So the larger estates, in particular the estates of the church, would offer incentives. Say, you come here and you can live rent-free for 10, 15, 20 years. Sorry, excuse me, I'm going to have to turn off the heating, which is starting to rumble.
Okay.
Sorry, I hope you can edit that out. So they passed a law in, I can't remember the exact date, but it was the early 1520s, that regulated the amount of labor service that you could charge to 1 day a week. That was to protect the lower, ordinary, middling nobility, who perhaps had only a few peasants, and they couldn't offer them as good terms as the big estates. And so they were trying to equalize the level of labor rent across the whole Commonwealth. And 1 day a week in the 16th century was not particularly onerous. In the second half of the 17th century and in the 18th century, it changed because economic circumstances changed for all sorts of reasons, partly in the 17th century, what's known as the general crisis, the Little Ice Age, the collapse of the market in Western Europe, and partly because of the wars, which devastated the rural economy. And lords started asking for more and more labor rent. I'm not trying to present this as some idyllic world in which lords treated their peasants wonderfully. They didn't necessarily. But the idea that this was an inherently oppressive system, it was a system that suited the agricultural economy, the agrarian economy of Eastern Europe.
Thank you. That's very helpful and elucidating, because of course I'm a product of the communist education, after all. But let me come back to your talk.
Oh, sorry. If I might say one more thing.
Of course.
Throughout the period, villagers who were subjects of the king, i.e. they lived in villages on the Królewszczyzna, which the king leased out or donated or gave to the nobility. Now that's 20% of the entire land surface of the economy. It varies from parts to parts. I mean, it's 50% in Royal Prussia. They had a right of appeal of their cases to what was known as the Referendaries Court, the Sąd Referendarski, and they did. They took their noble, the noble who was holding the starostwo or the royal estate. They did appeal cases to the king, and they were dealt with in this court. The picture was a lot more complicated than, frankly, the overgeneralized textbooks suggest.
As always things are, right? So let me come back now to your talk, because you made a distinction. Talk about the inquisitorial legal systems versus the adversarial. And for the people who are not lawyers, the inquisitorial systems, typically what you mean by that part of the court is actively participating in the resolution of the case. So we have it now, we have it in Germany, and it takes different forms. It's either the judge who actively investigates, or it's like, for example, public prosecutor in Germany, or things like that. And in the United States, for example, and also what I think you are applying, but I will ask you this in a second, is that in Polish-Lithuanian Commonwealth, or in actually in the United States, we have adversarial system that people are presenting, both sides are presenting their best case. The judge, in a sense, is kind of the impartial person, assuring that the rules and laws are followed. And in the United States, we have a jury system that actually is the deciding kind of organ. But ultimately, so there is this distinction. And then you mentioned something, and I think this was the thought from the Ukrainian researcher, I forgot her name, Natalia
Starchenko.
Natalia Starchenko, yes. She was mentioning that those courts, the Polish courts, kind of function as a theater. So I had a comment on that, because I don't think it has so much to do with like inquisitorial versus like adversarial system, but it has to do that law is ultimately a performative art. If you are in court, if you are arguing for the case, and that goes from Julius Caesar or Cicero to all the way to the current jury selection and how the lawyers are performing. Ultimately, it's performative art. It's just every litigation is, because you're trying to convince somebody, and I don't care, is it jury, is it the judge, or is it the prosecutor? Whoever is the deciding party, it's still a performance. So like, I think a difference between like this performative arts versus system of the courts, the inquisitorial or judicial, and kind of was wondering what's your comment on that?
Yes, I would agree. I'm not sure that the system that operated in Poland and Lithuania was necessarily the same as the jury-based system of the Anglo-American tradition. There were these judges who sat, and they would make judgments, and they would try and resolve the case. Frequently, I think, as happens in the modern American judicial system, the cases came to the local court, and there were the registration of these documents and these accusations and counter accusations, which was part of a theater of appealing to local Schlachter opinion. And perhaps quite a large number of these cases never actually reached a formal judgment. But, I'm tentative on that, because I've not carried out the research into these local castle court cases. I'm reliant on the work of others. But that's my impression, that a lot of these was these families seeking to preserve their own. That's what I'm drawing from the work of Natalia Starchenko and others, that you protest your version, other version. The lawyers, the judges try to bring both sides together to see if some sort of accommodation can be reached, some settlement can be reached, what we would call an out-of-court settlement, I suppose, and arbitrate between the two sides. And where that doesn't work, there's a judgment. That judgment is appealed by the losing party, and that judgment is certainly issued by these local courts, and then the appeal goes to the tribunal, and the tribunal considers it, and then it can go up, as I said, to the same court in the center. But it is essentially an adversarial system. It's not a system whereby the sovereign power sends his investigating magistrate out to issue a judgment, as you would have in, say, France in the early modern period. Although, of course, France has the parlements, which are again a different way of doing things. But nevertheless, that's how I see it, and that's why they believe in the system. They're constantly rushing to the castle court to register their judgments. Now, I think at the end of the session, when you posed the question about how does this system function later on, there were problems with the system. And what I was talking about was a system that operated in what I would call the sort of high point of the Republic, the days down to 1648, when I think the system, for all its faults, actually functioned more or less. It was capable of defending itself against multiple enemies. It was capable of administering justice in a way that Schlachter society could accept. After 1648, things changed for various reasons, and there are problems. They find in the second half of the 17th century, they're finding increasing problems in finding candidates to serve as the local judges. People don't want to serve for various reasons. Partly it's attempts by great magnates in various areas to dominate the local court system and faction fights and all the rest of it. But the system does come under serious pressure, particularly when rebellion and civil war and then foreign invasion comes in. But nevertheless, in its essence, it remains. And if it doesn't live up to its high ideals, then what system does?
That's very helpful. So you also mentioned that in a way that Schlachter courts function as a kind of way of restoring the particular family honor, and rather than kind of imposing kind of justice by the state or whatever, uniform justice. The executive power of the courts was very poor. The execution of the judgment was poor. We know there was forum. We know that nobles often have 3 different judgments with different judgments in different courts, which was really forum shopping. And then there is a question which judgment would apply. You need a higher authority for that. So that was happening. So can you kind of comment on this kind of role? Because, and also your talk was focused mostly on the violence cases, and maybe it was just the data that you have. We know the data is lost. So there wasn't much talk about, like the contract disputes, the land disputes. It was mostly about, the violence, the ruffians, the typical behavior.
There were, of course, endless property disputes, but one of the things that strikes me about the property within this Schlachter society was that there is a very strong tradition of customary law of upholding the norms of a system of partible inheritance in which families divide up their property constantly. Because if a noble family has 2 or 3 sons and 2 or 3 daughters, there are certain cultural norms and certain common law principles that they apply. The property is divided up equitably. And it is one interesting feature is that the rights of daughters, the rights of women in the early modern period are protected, particularly under Lithuanian law, which is codified. A third of the estate for the women in the family. And, they divide up property in what seems an economically senseless way. In the chapter I write about this in the book, I start off with a family called Sobieski. It's not that Sobieski family, it's another Sobieski family, where the father dies and there are 3 sons. And this family, the father, owns 2 villages. And so they divide up those 2 villages exactly between the 3 of them, which makes no economic sense at all. And everything is divided up, the movable property, the immovable property, and don't get me into the difference between movable and immovable property under Polish law, because that is a very interesting but rather arcane discussion. chickens were regarded as one thing and cows were regarded as another. But stools and mirrors, things that were fixed to the wall. Even if they own buildings, they might have a building in the town, local town that they own, and they'll divide it up into three. So one son gets one floor, one son gets another floor, and another son, this of course leads to endless disputes. But on the whole, the system upholds the right, and it upholds the rights of younger children. So sometimes they don't reach a final division of the property until decades after the father died, because they're waiting for the younger son to come in. And of course, you've got the rights of widows, you've got the rights of daughters, you've got dowries, you've got dowers. And yes, there are endless disputes, but then I'm sure as a lawyer you would agree that most of what courts deal with is property disputes. But one of the problems, historians have a problem. We use court records because they are so wonderful. And yet court records are all about when the system goes wrong. And it's very easy for us to extrapolate from that and say this was a dysfunctional system. But how many people actually end up in court? And it's the people who don't end up in court that are interesting, because they are the ones that are obeying the legal norms of their society. The trouble is they don't leave the records because they're not in dispute. And we have to be careful about giving a picture of can you give a valid picture of marriage by concentrating on spectacular divorce cases where the parties hate each other? Not necessarily.
Fair enough, and that's exactly the question I was going to ask you about the comparative. Comparatively speaking, you mentioned so many cases, and you mentioned that one of the researchers was kind of selectively choosing certain periods by which to record the cases of violence and personal kind of, the typical Polish ruffians, the kind of Polskie Warholstwo as we know it. But at the same time, how does it compare to any other society? Because those numbers in abstract are very different. First of all, I understand the data problems because clearly they are missing records. You mentioned another problem. Is this representative sample at all? So the sampling itself is an issue. But generally speaking, how would you compare it to, let's say, France or Germany or UK? Was there any less violence? Is it typical that violence was very typical of Poland? What do you conclude of that?
Well, I'm no expert on 17th and 18th century England, but from what I've seen, the little that I've looked at, they say that 17th, 18th century England was a violent society where incidence of violence was much higher than it would be today. This was an armed society. People wore swords, people carried pistols. And I'm not sure that, that comparisons have been carried out. It was a violent society. And it may have been more violent than other societies, but then it was a society that experienced a great deal of, particularly from the mid-17th century, war of bands of soldiers roaming the countryside. Poland went through, after 1648, Poland-Lithuania went through in many regions what Germany had experienced in the 30 Years' War. The collapse of order, roaming bands of marauding soldiers who hadn't been paid, all that sort of problem. And yeah, it was a more violent society than today. But then, of course, for a Brit, modern America is a pretty violent society. When we look at your homicide rates, I still get nervous when I see policemen carrying guns.
Yeah, no, and that's what Steven Pinker argues, the better angel of our nature. He argues that progressively, when you're looking at the amount of violence over history, it's diminishing. So, there are arguments to that effect everywhere, actually. So that brings me to another question about the role of Catholic Church in all of that, because the impression that I get, and I'm not a professional historian, but the impression that I get or was taught is that the Slavic Poland, the early Slavic Poland, was relatively tolerant society, and at least we have this whole sort of, of various Polish lawyers who are trying to develop theories of toleration because they are exactly under pressure of the Teutonic Knights or the Germans, the forced Christianization, like the Lithuanians or the Prussians, actually the original Prussian Slavs who are exterminated, or the Western Slavs, etc. So they are trying to be tolerant because it suits them, and the Warsaw Compact. And in fact, Goślicki, who is the Polish lawyer, but also a thinker and also a bishop, and he writes this book, De Optimo Senatore, very much, talking about the Roman Republic, Roman law, etc. Goślicki gets excommunicated for signing the Warsaw Compact. He was the only church official. He gets excommunicated. And we also are seeing all these records that, with Jesuits, Poland turns more, more Catholic, quote unquote, more kind of authoritarian in that respect. And this is a kind of bad news for this very diverse society, because how do you cope with this diversity? You have Lithuanians, you have Belarusians, you have thousands of other minorities, not minorities, different groups, and I don't even know how to call them because they are not exactly ethnic or national groups like, but at the time they were different groups. So can you comment on the role of Catholic Church, positive, negative, or maybe we should avoid judgment, just kind of figure out what it meant?
It depends what Catholic Church you're talking about, because the Polish Catholic Church was not, it was a powerful body, but it was not necessarily a uniform body, especially in the 16th century. And here I would make a point about the problem between Polish and English in the sense that Polish has one word, tolerancja, for the two English words, toleration and tolerance. 16th and 17th century Polish society was not necessarily a society that believed in tolerance, in the idea that your religion is your own private affair.
Right.
It was tolerant in the sense that, yes, the Warsaw Confederation was passed, but it's a much misunderstood document, and claims about it are frequently overblown.
Mm-hmm.
All that it was a document, a confederation that was put out and formally agreed during the first interregnum. Partly because one of the candidates in that was Henry of Valois, who had just been responsible or been involved in the massacre of St. Bartholomew in France. And all that the Warsaw Confederation says, in effect, is that we will not kill each other. We will not kill each other or take each other to court for religious reasons. It gives no guarantees of the right of dissident churches. It says dissidentes in religione, religious dissidents. That includes Catholics. People who disagree about religion will not kill each other and will not start court proceedings on the grounds of religion. Because in fact, the Warsaw Confederation, only, I think it's 2 or 3 of the articles deal with religion at all. The whole purpose of the Warsaw Confederation is to keep the peace during the interregnum when you don't have a king, and therefore the law is suspended. What do you do about that? And it's one of the great achievements of Polish republicanism that the interregnum, they sought that problem. The Republic shows, it says, during the interregnum, we will form these hooded courts, the sądy kapturowe, which will deal with criminal cases where necessary, and they'll deal with them at the local level. But we cannot have a full justice system until the king returns. The tribunals don't exist yet. We will not deal with civil cases because we can't. That seems to me to be a very mature political system that takes a pragmatic decision. But the Warsaw Confederation is precisely about that, keeping order in the interregnum. And that's what the Catholic hierarchy objects to. They say, look, this was just about keeping order during the interregnum. It has no legal force. It was not agreed by a Sejm, a proper Sejm with the king there, and they refused to accept it. And I would say that one of the problems in the judicial system comes through the strong counter-Reformation thrust that comes increasingly to dominate the hierarchy. The Jesuits are particularly involved in this. But there's another kind of Catholicism in Poland, which I term Republican Catholicism, which is more tolerant. It's part of what comes out of Renaissance Catholicism, where the Church, down to the Council of Trent, is not sure how to deal with Protestantism and the Protestant challenge. If you look at people like, well, Archbishop Uchański, Jakub Uchański, who becomes the Archbishop of Gniezno, I think he's the only Polish primate that is actually arraigned for heresy, because he takes an interest in, like many Catholic clergymen, he's interested in the ideas of the Reformation and spends that period of the early Reformation thinking well, there's bits of this I can go along with, but there's other bits I can't go along with. And there's a hope down into the 1560s that there might be some sort of national solution in Poland, that a national church might emerge of some kind that's a compromise between the radicals or the ideas on both sides, the moderate Catholics, the moderate reformers. Of course, it comes to nothing. But one of the remarkable features about that period is how religion in politics actually doesn't play a major role. You have speakers of the same, elected many times, who are Arians. They're not just Protestants, they deny the Trinity. You have major magnates who go along with Arianism, with Socinianism. This is remarkable in Europe. You know, the candidatures in the early interregna, religion doesn't really play a part. Yes, of course, the Catholic hierarchy says we're not having a Protestant. But Protestants will accept Catholic candidates. There are Catholics who even support Protestant candidate, the possibility of a Protestant candidate. And the hardline Catholic ideas of somebody like Stanisław Hozjusz, who chairs some of the final sessions of the Council of Trent on behalf of the Pope, you know, he is hardline. He is, yes, we will have agreement, but on our terms, with regard to the Orthodox, with regard to the Catholics. And it's the hardliners who are the problem, because they increasingly come to dominate. And they are not tolerant at all. They refuse to accept the Warsaw Confederation. And the Protestants and many moderate Catholic noblemen try to get some sort of teeth given to the Warsaw Confederation, i.e. some sorts of guarantees, political guarantees of religious freedom. They never get them. Because in a consensual system where the Sejm has to reach a consensus, the Catholic hierarchy is always going to blow these apart in the Senate. And that matters because one of the reasons that the system comes under increasing strain, you can see in 1648. Why does Bohdan Chmielnicki, who has served the Republic, he's been the secretary of the Cossack host, he's one of the registered Cossacks, why does Chmielnicki start his great rebellion? In part, it's because of a case he brings in the local land court. In the local court against Chapliński, a Catholic nobleman. Can an Orthodox citizen receive justice from a court that's now increasingly dominated by Catholics? That might not matter in the Mazovia, but it sure as hell matters in the Palatinate of Kiev and Bratslav and Volhynia, where the Orthodox have become, well, second-class citizens, where Uniates have become second-class citizens because the Catholic hierarchy won't accept them and spends endless time arguing with them over church property. And so religion undermines that. As modern America will know, where you have some people who are regarded or treated as second-class citizens that don't have the full rights citizens, that you try and exclude from voting in various ways. That is when a consensual system comes under serious trouble. And the Cossack revolt in the Ukrainian Palatinates was the result of that. So the Catholic Church, I'm afraid, does bear some of the responsibility for what goes wrong in the Commonwealth.
Yes, yes. Hozjusz was the one who said that Poland has become a heaven for the heretics, and the Piotr Skarga and the whole thing. It's like really very interesting to read this, that literature. But yeah.
But you can see, there are positive sides. You can see Zbaraski, one of the great Ukrainian magnates. The Jesuits turn up and he says, "Get lost! I want nothing to do with you, because you bring religious division. I have Orthodox subjects," and many of these great magnates, like Ostrogski himself, they support Catholicism, they support Protestantism, they support the Orthodox Church. Of course, Ostrogski supports the Orthodox Church most, but many of them are tolerant in the sense of they allow differing religious communities to exist on their estates. They support them. But gradually, it's an irony that Poland in the 18th century, Poland-Lithuania in the 18th century, is held up as a haven of intolerance by states that are pretty intolerant themselves. The British get on their high horse about the bloodbath of Torun in the 1720s. but Catholic emancipation is only granted in Britain in 1829.
Right.
Full rights for Catholics. So we have got nothing to be proud about on that front.
Right. So final question. I do have to respect your time, and I would love to ask this for another hour, but we only can answer for. And I don't know if you even can answer that question. You partially answered that question already. Is the role of women in this whole system? Like, have you seen cases in which women brought cases when they were actually active litigants? Have you seen?
Oh yeah, all the time.
Can you talk about?
Oh yeah.
That's fine.
Yes, as I said, the property laws are, in terms of Europe, pretty generous to women. And by the 18th century, you have great female heiresses like Szienawska, like Isabella Czartoryska, and others, because property can go through them, and they are certainly active. Widows have a place in society and have right. I mean, in fact, this is a tradition that goes back very far in Lithuania. Widows were sometimes summoned in the 15th century. Widows were summoned to the Lithuanian Soim. Not very often, but some of them were. That is rather remarkable, because they were the holders of the family. They were the representatives of the family, until, of course, they married somebody else, if they married somebody else. But a sensible, wealthy widow might not marry anybody else. And women play an important role. But yeah, oh yes, women are litigants. Jews are litigants in courts sometimes. They have a completely separate system of justice. But the law, the Lithuanian law, thanks to the codification of Lithuanian law, is different to Polish law. So, in fact, one of the problems in homicide, I mean, you asked about peasants, and in homicide, there is this problem that in the late 15th century, penalties are introduced for murdering. If a noble murders a commoner, they have to pay 10 marks compensation. If a noble murders a noble by a statute of 1496, he has to pay 120 marks plus spend, as I said in the talk, a year and 6 months in the Tower. And then in 1532, a peasant who murdered a noble is executed. So there's no execution for a noble murdering a. Now, this has caused outrage. This is a hierarchical oppressive system. And yet, under the law of the Grand Duchy of Lithuania, Chapter 12, Article 1, in certain circumstances, a nobleman who murders a peasant is held to justice and can be executed. And indeed, under Article 7, a nobleman who murders a Jew can be executed. Now, it takes a great deal to be executed. You have to have 7 witnesses of good character. As I said, you have to be virtually caught in flagrante delicto. You have to have 7 witnesses of good character, 2 of whom have to be nobles, to reach this. So I have no idea how many cases there actually were, but there's even a marginal note in one of the editions of the Third Statute of Lithuania, which says the Poles haven't quite got round to this. Now, when the execution for peasants murdering nobles was brought in the 1532 statute, it causes a storm. Andrzej Frycz-Modrzewski argues, and here I think Tom Burns asked about honor cultures and dignity cultures. Well, it's not a distinction that I find particularly helpful. I'm afraid I'm not a social scientist, and I don't like these labels that get placed on highly complex societies. Yes, of course, Schlachter society was in that sense an honor society, but there was a sense of the dignity of man that was partly, and here I will be much more complimentary about the Catholic Church, partly out of that Catholic tradition of natural law, of the idea that all believers have equal value and dignity. And Frycz-Modrzewski writes 3 excoriating pamphlets saying this is unjust, that every subject should be equal before the law with regard to homicide, and therefore nobles should be executed in the right circumstances if they murder a peasant. It depends on the circumstances, of course. If it's self-defense, which the Lithuanian statute allows, if the noble kills a peasant in self-defense. And part of the reason for the 1532 statute in Poland was that there had been an increasing number of cases of nobles being murdered by peasants. And the nobility felt that this was needed to be dealt with. And we all know that public pressure, can lead to very illiberal laws being passed. And so, to return to that, Fritz Modrzewski, in his great book on advocating reform of the Republic, he argues, and you don't get this in the debate about honor cultures and dignity cultures is partly comes out of our smug satisfaction at being modern, and that honor cultures are medieval and dignity cultures are modern. Well, I'm afraid it's far more complicated than that. The Catholic Church does have, and Protestant churches as well, have this sense of the dignity of individuals. And Fritz Modrzewski says, look, if we are to be this community of virtuous citizens have virtue, and virtue does not come by birth. Jagiellonian says this. It's not a sort of hall full of painted coats of arms that make you noble. It is your behavior. It is your virtue that makes you noble. And therefore, Fritz Modrzewski is principally concerned that if you don't treat people equally before the law, then how can you claim to be a virtuous society? And so these ideas are there. Okay, Modrzewski doesn't win his argument,
right,
but it's a far more complex picture than the textbooks suggest. And that was not really an answer to your final question, but it was picking up the question you sent me from Tom Burns. So I hope that in part answers his question.
Yeah, I mean, look, and I had a similar question as a social scientist, as you said. We do have those easy theories, but there is a problem, because we have a correlational kind of analysis of societies, and it just so happens there is no causation there, but there is a correlational value of certain behaviors. So typically in an honor society, violence, women are held captive, there is very patriarchal kind of society, women are the holders of virtue that and you see that, and in this dignity so-called societies, you see a very different set of values, so they correlate. And the kind of funny thing is that if you ask somebody a very simple question, you can ask an average I don't know, person on the street in Poland, what's your view on environmental protection, and you will know what their view on abortion is, and on the current political party. It's highly correlative. Those for reasons I don't really understand, but it's correlated.
All these questions are complicated, but as I said at the end of my talk, I'm not trying to pretend that this was some kind of wonderful system that functioned. It didn't. But if we're going to look at it and research it and examine it and write about it, we need to try and understand what its own terms were. They didn't have the terms of honor cultures and dignity cultures. They dealt with them in their own terms. And these questions were difficult for them, as they are for us. But they dealt with them according to a very different set of moral precepts. And I'm not sure it's the job of a historian to spend their entire time judging the past for not being us. I think the function of a historian is to explain the past, which does not mean approving of the way things were done, but it's trying to understand why they were done in the way that they were done.
And thank you for doing it so wonderfully. I mean, your first volume is really enlightening, especially for a Pole, because somebody who is brought in a certain way, our society sees our own culture. It's very enlightening to see this as a perspective, and it's also carefully and so well researched and so well argued. So thank you for that. And thank you for this fantastic talk and for taking time for this Q&A. So please tell us, when can we expect your second volume? What can we see there? And what's the third volume is going to bring us?
Well, thank you for that. I think, as I've said in a number of places, I actually wrote, I think I say it in the preface of Volume 1, I wrote Volume 1 to explain things to myself because I didn't understand. I was an outsider. and things didn't make sense. So I tried to understand why things worked in this way, and some of the ways that historians wrote about them didn't make sense to me either, so I had to think it out for myself. And that's the advantage of being an outsider. I'm not a Pole. I'm not of Polish descent. I'm not a Catholic.
Right.
So many things were just not self-explanatory to me. Volume 2 is nearly finished. It goes up to 1648, and I think I've got 2 or 3 chapters. It depends how they pan out. I've planned 2 or 3 chapters, which would take me to the end of the reign of Władysław IV. And I hope, I mean, COVID and the immense demands of teaching this year have completely thrown the schedule into the air. But I hope that I can complete the draft by the end of the summer. And then I will move on to volume 3, which is called The Downfall of the Polish-Lithuanian Republic. And that will look at the problems brought by war, by the challenges of war, by the challenges of a changing world in which an international order emerged based on that idea of of Bodinian sovereignty. That's the way that the international system was structured after 1648, or increasingly structured after 1648. What was the place of this strange republic in that new world? And the Polish-Lithuanian Republic certainly struggles to find its place in that world. I think it does in 1791,
Yes.
but that was a little late.
Indeed. Indeed. Well, thank you so much, Professor Frost. This was just most enlightening. Thank you so very much. And I guess, I don't know how we're going to hear more. I guess people can look up your books, articles. We will have them listed on the website.
Thank you.
And, thank you very much.
A pleasure. Thank you very much, Elizabeth.
Thank you. Let's see. I do not have a clue how to stop recording. So, Robert, I guess I will have to edit this out. So, thanks so much.
Sure.
Should I have actually, I forgot to ask you, is there anything else you wanted to add? Because maybe let's place it in if you still want something that you need to turn.
Not really. I mean, I think I added my answer to Tom Burns's question
Yes.
at the end there, and that was about it.
Okay.
Just to thank you and hope that some of what I said made sense to my highly educated legal audience. I am not a lawyer.
They're a wonderful audience, and I hope that people will take something from it, because it truly is very difficult to wrap your mind about it. These are not ideas, as you said, that come intuitively to us, especially if you are under Polish system.
Yes, to quote L.P. Hartley, the past is another country. They do things differently there, and that's what I'm interested in, why they do things differently. Yeah. And one of the problems of the social scientist approach, I feel, is that social scientists are so caught up with modernity that they're looking for the roots of modernity everywhere, and that I don't think is a good way of explaining why things happen as they do. The last thing that anybody in the 17th century, I tell my students teaching Louis XIV, if you told Louis XIV that he was building the modern state and told him what that modern state consisted of, he'd have dropped dead of apoplexy. That was not at all what he was trying to do. And I think the same is true of the Polish-Lithuanian Republic, of the founding fathers of America.
Yeah. Yeah, no, I mean, from my perspective, I mean, not that, that kind of social scientist, I try to look at, I'm an archaeologist actually, and I look at the early foundation of social complexity and the economic foundation of social complexity. And what, so it's interesting, but what interests me is a kind of evolutionary analysis. If you look at a society in a much larger 200,000 years, how that evolved, it's very clear that certain and it's once you get very fine grained like the history, then I really had no idea. But on these very big chunks, you do see patterns that kind of make sense.
Oh yeah,
you
certainly see patterns, and
exactly.
I do. I read the works of social scientists and think actually there's something in that. But reading them makes me think, why is this wrong? Why can't I accept this idea? I find the sort of honor dignity division interesting. And I think there's something in it, but
I don't know what's in it, but it's correlative. That's the thing, the point I'm making. It's correlative, and I don't know why is it. There is this research from psychology that, you know, there are several psychologists who claim that you have like a molar flavor you are born with. Genetically speaking, you are born with certain values, so you are more open versus more closed, you like more boundaries versus, no, whatever, you know, that's the psychology, right? And so that if you have a certain view on you versus other, you are much more belonging to the group or more open to the outsider, etc., that would explain liberal versus conservative roughly. And they do have a correlation research, you know, through countries, etc., showing that this seems to hold. If you have those psychological traits, you're likely to be Republican. If you have the others, you're likely to be more liberal. Well, take it for what you want, you know.
Except you can get conservative Republicans and and liberal conservatives.
I know, and everything in between. I hear you.
Yeah.
Anyways,
Anyway,
thanks, Robert.
a pleasure, Elizabeth. I hope that you know the problems of the lecture will not have detracted from it.
No, I hope not, and I hope people will see it because your slides are so beautiful, so nicely done, and they are really helpful to see those pictures. I found that slide on the destruction of the archives incredibly moving because he says, yes, I know Polish history, I know how much it was lost, but seeing that picture, in a sense, and we're talking about the amount of records lost, that one picture.
Well, some of the other records that were lost were more or less the entire financial records of the central government.
Yeah.
And of course, if you haven't got the financial records, you can't show that this was actually a much more functional government than people think it was. It's easy to say, oh, well, it was dysfunctional and it had no financial sense at all. But we haven't got the records to find out whether that was true or not. And
I don't mean to interrupt, but I also want to, I was saying that, you know, Polish history always was taught by the oppressor. So literally, we were Germans and Russians explaining our history to us. During communism, certain things.
well, I'm not so sure about that. I mean, Poles always wrote their history, especially in the 19th century, and often they wrote it against the oppressors. But you know, if you look at particularly in Austrian Poland, in you know the great Polish, in Galicia, in Lvov, you know that's where the Polish historical profession emerged, and it was they wrote their own history. The problem is it's not their version of. I wrote in my book on the Northern Wars in the preface. I said that there's the saying, or it is said that it is the winners that write history. And I said, that's only partially true. Losers also write history, they just don't get translated. And that's the problem for Polish history, is that the version of East European history that was put out by Russian and German scholarship was the version that the Anglophone historical world took on board, because they didn't, you know, when I was thinking about doing Polish history, Jeffrey Parker said to me, are you thinking of doing a PhD on Polish history? And I said, maybe. And he said, yes, do, because we all know Poland was terribly important in the 16th and 17th centuries, but we know nothing about it because we can't read the language. And I thought, ooh, that's a good point. And so all that I've been wanting to do is to restore Poland to a proper picture of European history and say this place was important. And it's different and it matters.
Yeah, and the linguistic challenge to all this, I'm amazed that you can do this research, because the linguistic diversity alone, the Latin, the Russian, the Armenian, I mean, that's so many languages that were used by.
Well, and that's part of the problem, because of the domination of the nation state.
Right.
You know, the Poles write Polish history, the Ukrainians write Ukrainian history, the Belarusians write Belarusian history, and the Lithuanians write Lithuanian history. And it's only since 1989, really, that started to break down, and it's wonderful. And Natalia Starchenko is a wonderful example, because she is, you know, I sent her the podcast and said, you know, I'm trying to, you know, sort of publicize your book and your wonderful work. And she thanked me and said, you know, it's great. You know, and she's talked about something else she's doing in our Commonwealth. And there's a Ukrainian historian who's talking about our Commonwealth. And that's, you know, her doctoral supervisor was Natalia Yakovenko, who wrote this wonderful book on the Szlachta in Volhynia during the Commonwealth period. And there's now a growing school of Ukrainians who don't just write Cossack history and nasty Poles. They really are taking it on board. The Lithuanians are as well. And it's wonderful, because it's changing the way that the whole history is being written. But yeah, it is at times linguistically challenging. And that's one of the problems.
Yeah.
British historians can do everything in English, and they do. And they miss all the stuff that's written about Britain in foreign archives because they can't read the language. They can read, some of them can read French. Very few of them read German.
Interesting.
Okay, I better go.
Yes, I know. I would love to have it continue, but I know we have to go. So
well, I hope that it did the job for you, and that
it certainly did. And thank you so much. I'm so incredibly grateful for your incredible, I don't know how to even call it, your sense of the virtue that you actually recorded it and even spent time with me extra to answer the questions.
Well, you know, one of these days, one of the problems of the internet is, you know, you do one of these things and it goes up on the internet forever. And so I'd rather have a proper version that I've properly edited go up than one where I keep saying, oh, I better go and see if my daughter's using the internet, or I'm sorry, what was I saying?
Yeah, I hear you.
So
no, that is very, very much. It's a record. As a historian, you can appreciate it. All right. Thanks so much, Robert. Have a great day.
a pleasure. Yeah, and you. Bye.
You too. Bye-bye.